Hello, everybody. Welcome to the seminar, Selling Real Property During the Probate Process. I'm your host today, Scott Schomer. Before we get started, I thought we'd do quickly a little agenda. First up is an introduction to the Schomer Law Group, who we are and what we do. Next is what is a probate. After that, we're going to talk about the necessary steps to accept an offer to sell real property during probate administration. 4, we're going to talk about after an offer has been accepted, the confirmation hearing. That's kind of the scary part. 5 is selling property in probate with full IAEA authority, Independent Administration of Estates Act is what IAEA stands for. And then we're going to save some time for your questions and answers. The seminar is designed particularly towards real estate investors and realtors. We love realtors and real estate investors, and we're always happy to help people through a part of the probate process. So first up, let's talk about us a little bit. Who is the Schomer Law Group? So we are a trust and estates focused firm based in El Segundo, California. We serve primarily LA and Orange County, but we also serve some of the outlying counties just depending on what the matter is. Our practice is focused on estate planning, probate and trust litigation, probate and trust administration, conservatorships, tax planning, and also something called Medi-Cal planning, if you're familiar with that. Real briefly, my background is that I am a lawyer educated at Boston University. I've been a member of the bar, State Bar of California in good standing since 1990. I'm a certified specialist in this area in estate planning, trust, and probate law, certified by the State Bar of California. I'm the founder and principal of the Schomer Law Group and Schomer Wealth Advisors. I've been elected for the last 11 years running as a California super lawyer, a award reserved for the top 5% of people in our practice area, and also a 5-star wealth manager, and I'm also a lifetime member of the multi-million-dollar advocate program. But it's not just me. We have a whole team of almost 10 here. Next up is Bradley Kleige, who's really become one of our probate specialists here. He's a recent graduate of UCLA and Michigan State University, and probably gets to probate court at least 2 or 3 times a week, has handled a number of sales. We also have a new young lady, Lauren Moritz, who just got word on Friday that she had been admitted to the bar. She's a graduate of USC. And in addition, we have a whole team of paraprofessionals. In fact, that's Lauren down there on the bottom right-hand side. We're very proud of her. So that's who we are. If you spend some time and look us up on the web, you'll find that we have a very rich legacy and depth of knowledge. We probably have close to 1,000 blog posts. We write about this stuff all the time. We publish newsletters. If you give us your email address, we'll send you updates. We'd like to keep people very informed. Please consider us a resource. We want to make you look good to your clients. We are also members, because of our expertise, in the American Academy of Estate Planning Attorneys. It's a exclusive organization. I'm a fellow in that organization. We're one of only a few member firms in the area. And if you read Money Magazine says if you're looking for an estate planning or a probate attorney, look for somebody who's an Academy member, as did Susie Orman in her best-selling book, 9 Steps to Financial Freedom. So that's who we are and what we bring to the conversation. So next up is let's talk briefly about what probate is. I know we all sort of think it is, but real quickly, a few definitions. A probate is a lawsuit that you file against yourself for the benefit of your creditors, is how it's been once defined. It's also been defined as an official proving of a last will and testament, the process by which a will is approved, and it's also the first step in the legal administering of an estate. Going into some basic definitions in this realm, in California, the acceptance of a last will and testament is governed by statutory requirements. So there's something called a statutory form will. There's another will that's recognized as a self-proving will, and there are also holographic wills, which are handwritten. If you want to have a will be honored, it has to be completely handwritten in the decedent's handwriting, and it has to be signed. And finally, you can also present to the court an instrument that you think might be a will, provided you can prove it to them by clear and convincing evidence. But one of the questions I frequently get is, are there such things as audio or video wills? And generally there are not, unless you're able to convince a court that it should be honored under 6110C2 of the probate code. But that's generally what we're looking for. The person who is in charge of a probate is called broadly the personal representative. If a person is named in the will, they're known as the executor or executrix. If there is no will, or the person in the name of the will is not acting, then they're generally referred to as the administrator. This is the person if you're working as a realtor, the person that you're going to be working for, the personal representative or the executor or the administrator. These positions are fiduciary positions, which should not be confused with other fiduciary positions, such as a trustee. Trustees in charge of a trust, an agent under an attorney, under a power of attorney, known as an attorney in fact, a healthcare agent, a conservator, or a guardian. Those are all separate, independent positions. Probate is something that comes up after a person is gone, and we're talking about processing their assets left in their name. So what's the general process of how a probate commences? We start with somebody has to file a petition. Generally, it's the person that's named in a will, but it can be a loved one, it can be an heir at law, it can also be a creditor, but somebody has to open up and ask the court to commence a probate and appoint a personal representative. Once that's done, then the personal representative is given letters. Now, if you've never seen letters before, to you they will probably look like a court order, but essentially they are the fundamental document that is required for any administrator or personal representative to act. They are the things that give the person power to be able to act. Once that person is appointed, then letters are issued. The date that the letters are issued by the court is a critical date because it determines the minimum time requirement for how long a probate must be open. In California, it must be open for a minimum of 120 days. That's sometimes called the creditor claim period. During that period, the administrator will process and send out notice to creditors. They'll marshal, inventory, and appraise assets. And this is the period during which the administrator is going to most likely want to sell the real estate if you're being involved in a real estate sale. So it's during this creditor claim period. Finally, when all the process is done, the administrator is going to petition with an accounting and ask the court to close the estate and eventually distribute any assets that are remaining to the beneficiaries or the heirs at law. Administration at death public, if the assets, the reason you might not need to do this, the reason you want to commence a probate proceeding, I know it seems obvious, is if the decedent has assets in his or her name alone with no other arrangements. Often we refer to estate planning as probate avoidance. We're trying to avoid the probate court. But if no plans have been made, if no other processes have been put in place, then probate is the place we do it, and the executor is the boss. That's the person that's going to do it. So I've given you the basic time frames, but what do we do in a probate? Well, after we give notice to creditors, we resolve disputes, we inventory and appraise all the assets, we pay the creditors when the assets are available, we change title to assets. That may happen when they're distributed, and finally the assets are distributed. The advantages of probate, if you're not familiar with them, are briefly that it's judicial supervision of asset distribution. So if you have a family you don't trust, as we like to say sometimes, if it's done under the jurisdiction of the court, then you've got the watchful eye of the court and the probate referee to make sure that everybody's acting honestly. Probate also sets up a strict timeline for creditors. Creditors have to file claims within the probate administration period, or they're forever barred, no matter how meritorious. And the court, of course, supervises what the administrator does. So those are some of the benefits. What are the disadvantages? Why do you want to avoid probate? The simple answer is that it's time and money. The average cost of California is 4 to 8% of the gross value of the assets. So on a house that's worth, on a gross basis, $1 million, you're looking at close to $50,000 of fees and costs. It's an expensive way to transfer assets. Finally, it's time consuming. At a minimum, we're looking at about 9 months, but it can frequently take several years. And these things are all open to the public. And if you have assets in other states, so for instance, if your main house is here and you have a second house in North Carolina, or a rental property in North Carolina, you may have to open up 2 or 3 probates, just depending on what the situation is. So that's your general overview of probate and how it works. So part 3, what are we going to talk about next, is what are the necessary steps to accept an offer to sell probate sell real property in a probate administration. So if you're helping with a client or administrator, the first thing we want to ask is, does the property need to be sold subject to court confirmation? Some but not all sales must be sold subject to the process that is known as court confirmation. This is usually determined on whether or not the personal representative has either full or limited powers under the Independent Administration of Estates Act, the IAEA. But even in the presence of full IAEA powers, some personal representatives still insist on selling property via the court confirmation process. Then the reason generally for that is that it insulates them and protects them from liability. So try to figure that out. If your client, the representative, doesn't know, that's a great question that needs to go to the attorney. Don't be afraid to work with the attorney, contact the attorney in this type of situation. Next is we have to ask ourselves whether the will has any specific directions on the sale of real property. This is definitely something you should review. Some wills contain specific instructions about how or when the real property assets must or should be sold. The court has possession of any original wills, and they're going to consider that before authorizing any sale, and it should be examined before you get the whole process started. Next is the probate listing agreements. So this is one place I see realtors get themselves into trouble on a regular basis. The personal representative may not enter into an exclusive listing agreement for an original period not to exceed 90 days. Any agreement that goes beyond that, you're going to have to get court approval. You can include one or more extensions for the same period, except if the court requires approval for under limited IAEA authority. The extensions go beyond 270 days, the administrator is going to require to send out what's called a notice of proposed action or get prior approval from the court. So be careful about that listing period. That's a very important thing for you. Next, before you accept or before you allow your client to accept any offer, has the estate published notice of the sale? Publishing notice of the sale is a step that is frequently overlooked, and if not coordinated with the attorney, can result in denial of a petition. The notice of sale must be used unless the will gives the personal representative full IAEA powers, and the court has granted those. If the personal representative intends a private sale, which is the most common, the notice must indicate the day on which the offer can be accepted. If the personal representative intends to auction the property, it also must list the date of the auction. So when you're publishing the notice of sale must contain the day on or after which the offer can be accepted and the day on which the auction is happening if it's attended. Now, you as the realtor should not be the person that's having to deal with this. Again, this is the responsibility of the personal representative. More realistically, it's the duty of the attorney. So do not be afraid to work with the attorney, talk to the attorney to make sure these things are done before any offer is accepted. The notice of sale must be published at least 3 times over a period of not less than 10 days, with the third publication at least 5 days after the first, and the date of the auction if there's one intended. The offer cannot be accepted until after the time to publish has expired. So I have literally seen situations where the notice of sale period expires on June 1st and the offer is accepted on May 25th. And that's not a valid offer. You have to basically start over again. You can create a world of hurt and liability for your client. So be very careful with this step. If the offer is accepted prior to the expiration, the offer is invalid and the process must start anew. Before you let any personal representative accept an offer, make sure you have conferred with counsel and that you have your timing correct. Commission amounts. What is the common amount? In Los Angeles County, total commission shall not exceed 5% for improved property and 10% for unimproved or raw land. There is a prohibition on paying a commission where the agent, directly or indirectly, is a purchaser of the property. This is another place that I've seen agents get in trouble. So if you're buying on your own behalf, you cannot pay yourself a commission. You must get somebody else to represent you in that situation. Before the confirmation hearing, the next question is, has the personal representative obtained a current appraisal? Real property and probates can only be sold if the sale price is not less than the 90% of the appraised value. And the appraisal must be less than 1 year old. But remember, do not call your favorite appraiser. In probate proceedings, all assets must be appraised by the probate referee. The probate referee is somebody that is appointed by the court. So make sure you have a probate referee appointed. Make sure that the probate referee has reviewed and issued an appraisal. Make sure you're within 90%, and make sure the appraisal is not more than 1 year old. Now, if you're selling something less than a 100% interest in the real property, unlike a private sale, there's a limitation here. A partial interest cannot be sold without the consent of all the co-owners. So you have a non-consenting co-owner, what the personal representative is required to do in that situation is ask for permission and proceed with a partition of the real property. So be very careful about partial interest. That's another thing that should raise a red flag. It's always a wise idea when you're about to publish the notice of sale that you have the agent review the draft notice before it is published to ensure accuracy. The things we want to do is we want to make sure that the property address and description is accurate. We want to make sure that the terms of the sale are accurate, and we want to make sure the terms of the sale are as is, and whether or not they're conditioned on court approval. Okay, so these are a number of technical requirements that are not typically required in a standard real property transaction. You need to make sure you follow all of these steps. Again, because it's complicated, do not hesitate to turn to the attorney to make sure that everything is being done correctly. So we've accepted an offer. Everything looks to be in order. Now we have to petition to have the court confirm the purchase agreement and have the property subject to overbid. So what are the next steps? So the sale confirmation process is started by the personal representative through the attorney filing a petition asking the court to confirm the sale. In Los Angeles County, the petition is usually scheduled for a hearing 70 days after it's filed. So if you have a buyer that comes in and says, I expect to close in 2 weeks, or I expect to close in 30 days, realize that this is a more extensive process and much of it is out of your hand. Interesting story, I actually bought my own personal residence through one of these processes many, many years ago. And our court confirmation didn't happen for almost 120 days. So these things just take time. Notice of the court confirmation hearing should be given to all parties and their agents. Acceptance of any offers conditioned on the court's approving of the sale. The fun part, this is where it gets really interesting, is that any qualified buyer can appear at the confirmation here on the date of the sale and submit a bid. So during this period, while you're waiting for the court to approve the sale, one of your duties as an agent is to continue marketing the property. The sales are always as is, where is, so you want to tell their potential buyers the opportunity to inspect and review the property. You want to keep generating interest. The purpose of the confirmation process is to generate the highest sale price for the estate. So keep doing your job. Your job has not ended simply because an offer has been accepted. Failure to allow an inspection can result in continuation of the confirmation hearing. I've seen this happen before, where they get to the hearing and a buyer shows up and says, I wasn't allowed to inspect and I really want to bid, but I wasn't allowed to do this. So make sure you realize that your job as the agent is not finished at that point. The sale can only go forward if the buyer or a representative of the buyer is present. They must be present in court. So make sure that your buyer and or you, if you're representing the buyer, know the date, place, and location, and know how to park and know how to get to court on time. Sometimes these things start right on time. Often they're the first matters that are called in calendar, so you don't want to be late. Failure to appear can result in the court denying the sale or forcing the process to restart, or subject any potential buyer to damages for having to reconduct the sale. Also, a potential buyer can be overbid by another buyer even if he or she is not present in court. Next up is overbidding and qualifying for the sale. So as I indicated before, the sale is not finished until the judge approves it. So in other words, nothing is final until the judge drops the gavel, which sometimes they actually do, and the sale terms are confirmed. Again, this process is designed to maximize exposure and get the highest value for the property in a probate proceeding. If you are representing a potential overbidder, you first of all need to be prepared with a deposit, which is typically 10% of the first overbid price and sufficient qualification for the financing of the balance. If you're representing a potential buyer, the best thing to do is to call the listing realtor, listing agent or broker, and find out what they need to make sure that your buyer is qualified before you show up and overbid. It's stressful enough when you're in court and you're actually doing this auction. Make sure you know the exact amount, because you need to come with, your buyer needs to come with good funds for the down payment. Failure to bring these items can result in precluding a potential bidder. And that's why it's good to communicate with the listing agent ahead of time. The first overbid amount is determined by the sale amount plus 5% and $500. So you just sit and do your math, and that's generally going to have to be the opening bid for one of the parties. You're going to have to show up with 10% of that deposit plus proof that you're going to be able to complete the purchase in a timely manner. After that, the sale can go through multiple bids. So the first overbid amount might be, let's say, $500,000. The court may decide the next bid after that is $500,000 and $5,000, or $500,000 and $10,000. It just depends on what the judge does and what the parties are. I've seen a number of sales where the parties have gone through multiple bids on one property. Decisions must be made fast, and potential buyers are well advised to have considered their financial limits, because once the court orders the sale to your client, the only way that doesn't go through is that it has to be undone by the court, which means fees and costs and damages for any potential bidder that can't close. Okay. In Los Angeles County, overbidders must complete and prepare and be prepared to submit a court order if they're the successful bidder. And there's an actual form for this, which you can find on the Los Angeles County Superior Court website. And I've given you the address there. It's lasuperiorcourt.org. In the bid form, it requires the details of the names of the purchaser, sale terms, commission division, and manner of vesting. Parties must also should be prepared to orally advise the court on the manner in which they want the title to be vested. So this is something that's really, really important. And I see a number of people will get hung up on it. So they're buying it and they're just thinking, of course I'm going to buy it. And the judge will look at them and say, how do you want to hold title? I don't know. Can I think about it? No, you can't think about it. The judge needs an answer right then and there. So it's going to be in your name. You need to say Scott Schomer is a married man. Or you need to, if you're going to put it into an LLC, you need to say it's this LLC and here's the name of the LLC. Property Holdings LLC, a California LLC. So be prepared with that ahead of time. Okay, that's the process for selling property subject to court confirmation with limited authority. There's also the situation where you're selling real estate property in a probate when your administrator has full authority. If you go back to the beginning, you remember this was really one of our first questions is, do we have full or limited authority in a probate? Selling with full authority still requires that you give notice to all the beneficiaries before the sale. Our recommendation and the requirement is that the purchase offer must contain language advising that the seller's acceptance of the offer is conditioned on full compliance with what's referred to as the notice of proposed action procedure. That's found in the probate code, and your attorney should be very familiar with it. Once a purchase agreement offer is signed, the attorney must serve a copy, fully signed copy of the purchase offer with the notice of proposed action on all of the heirs or beneficiaries or interested parties in the probate. The seller's acceptance of this is not effective until the 15 days has passed without any objections. If one of the beneficiaries comes along and says, no, 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 I object, I think you're selling it for too low, then the notice of proposed action gives the seller the right to cancel the listing and back out without penalty. So the point here is what we're trying to do is protect the fiduciary, protect the administrator or the personal representative or the executor. So we want to make sure that the notice of proposed action process is complied with. If there are objections, you can negotiate with the objecting beneficiary, or the administrator can go into court and seek directions. Hey, beneficiary Joe thinks that I've undersold it, but I've had it on the market for 3 months and nobody's made me a better offer. Court, tell me what to do. Or they can cancel the sale. Failure to comply with this process, again, makes the administrator vulnerable to later attack or even a possible surcharge for underselling it. So that's your basic process. And I appreciate you listening today. Hopefully, I know we went through a lot of materials. One of the things we're going to do is if you submit an email address to us, we'd be happy to submit to you a report that summarizes the sum and substance of this PowerPoint. And at this point, I will open up the presentation for any questions.